If you're a landlord, you need to know about a new case that came down from the Mass Appeals Court. It's about evicting a tenant right after they filed a complaint with the Board of Health. And if you don't follow the rules, you could find yourself in hot water and potentially not be able to evict your tenant. Today I'm breaking down that new case, which is Campbell v. Abdullah. And the reason it matters is it makes clear that the retaliation defense that a tenant can raise if there is a complaint to a regulatory body like the Board of Health, that applies in both a fault and no fault eviction. That means the timing and documentation are really important in making sure that you build a strong case to support your summary process eviction. So we're going to look at the facts, what the housing court got wrong, and what the appeals court says, and what it means for property owners going forward when they're looking at an eviction after there has been a complaint filed with the Board of Health. So this decision was written by Judge Hirschfang, and this is a summary process case in which the tenant, Tanya Coffey, appeals from a judgment of possession in favor of her landlord. After Coffey reported concerns about her apartment to the Haverhill Board of Health, a notice of violation issued to her landlord. The next month, the landlord served Coffey and her family, collectively the tenants, with a notice to quit for cause. The tenant's answer raised affirmative defenses, including retaliation under GLC 239 Section 2A and counterclaim for damages under 186 Section 18. After a bench trial, a judge of the housing court found the landlord had established at least one of the cause allegations contained in the notice to quit and awarded him possession and costs. Although the judge acknowledged the tenant's facially viable retaliation defense, he interpreted GLC 239 Section 8A as precluding the defense because this was an eviction for cause rather than non-payment of rent. We vacate the judgment and remand for further proceedings. So vacating the judgment simply means that they are overturning what the lower court decided in terms of issuing a judgment for possession, and remand means that it's sent back to the housing court to continue the case and to resolve any issues. So, background. For many years, the tenants lived in the landlord's apartment pursuant to a written lease for tenancy at will. In June of 2022, Coffey noticed that the back of her refrigerator, the interior of her oven, and the walls of her home had been damaged. She believed that rodents were responsible. She notified the landlord asking to have the situation remedied as soon as possible. In August of 2022, Coffey also notified the Board of Health of the infestation. An inspection on August 29th of 22 revealed evidence that rodents, including rodent droppings and a mouse, as well as other violations, triggering a notice of violations dated the next day. In September of 22, the landlord served the tenants with a 30-day notice to quit for cause. The notice to quit detailed several claimed violations of the lease. After a jury-waived trial at which both the landlord and Coffey testified, the judge found that the tenants had committed multiple lease violations. Although the judge acknowledged the tenants' affirmative defenses, including retaliation, he did not consider them. Instead, he concluded that because the landlord terminated the defendant's tenancy for cause, affirmative defenses were not available to the defendants under GLC 239 Section 8A. Coffey asserts that the judge erred by concluding that the statutory defense of retaliation was not available in this for-cause eviction. We agree. We review questions of statutory interpretation de novo, beginning with the plain language of the statute. We presume, as we must, that the legislature intended what the words of the statute say. As the judge acknowledged, GLC 239 Section 2A creates a defense of retaliatory actions for summary process. The statute reads in pertinent part, "It shall be a defense to an action for summary process that such action was taken against the tenant for the tenant's act of commencing, proceeding with, or obtaining relief in any judicial or administrative action, the purpose of which action was to obtain damages under or otherwise enforce any federal, state, or local law, regulation, bylaw, or ordinance which has as its objective the regulation of residential premises, or reporting a violation or suspected violation of law as provided in Section 18 of Chapter 186. By statute, if a landlord commences an action within 6 months of such a complaint, a presumption of retaliation arises. The landlord sent the notice to quit within a month of Coffey's complaint to the Board of Health. Therefore, the statutory presumption of retaliation arose here, triggering the landlord's obligation to prove by clear and convincing evidence that his action was not a reprisal against the tenant, and that he had sufficient independent justification for taking such action, and would have, in fact, taken such action in the same manner and at the same time the action was taken, regardless of the tenants engaging in or belief the tenants had engaged in protected reporting. Here, though, the judge determined that the retaliation defense was foreclosed by the language of GLC 239 Section 8A. The statute reads in pertinent part, in any action under this chapter to recover possession of any premises rented or leased for dwelling purposes brought pursuant to a notice to quit for non-payment of rent, or where the tenancy has been terminated without fault of the tenant or occupant, the tenant or occupant shall be entitled to raise by defense or counterclaim any claim against the plaintiff relating to or arising out of such property, rental, tenancy, or occupancy for breach of warranty or breach of any material provision of the rental agreement or for a violation of other law. Citing this language, the judge concluded that because their tenancy had been terminated for cause, affirmative defenses were not available to the defendants. This was error. Section 8A is not the exclusive authority for defenses and counterclaims in summary process. The paired retaliation presumptions in GLC 186 Section 18 as to counterclaims and 239 Section 2A as to defense apply to for-cause evictions. A rebuttable presumption arises whether or not the action was for non-payment of rent. Accordingly, we vacate the judgment and remand for additional proceedings consistent with this opinion. So what's the takeaway? The appeals court ruled that the tenants can claim retaliation in for-cause evictions if you move to evict within 6 months of somebody making a complaint to the Board of Health or taking judicial action, that presumption will arise, and the burden will actually transfer to the landlord. The burden means that now the landlord has to prove by clear and convincing evidence that the eviction had nothing to do with the reporting of the substandard condition or taking judicial action, and clear and convincing evidence is really high. So in civil actions, our ordinary standard is preponderance of the evidence, which means that it's just slightly more likely than not. So it's just over that 50% threshold. Clear and convincing evidence is much higher, and it's much harder to prove. So the practical takeaway is that we need to document everything as landlords. If you have a real cause, like lease violations or damage to the property or illegal activity, you need to make sure that you have strong records and a strong case to actually survive either a defense or a counterclaim. And you should be careful with timing. Even valid evictions can be derailed if the court thinks that it's retaliatory. And so some good evidence would be if you told the tenant in writing that you were planning to evict them in the future, and then they went out and got that, sent that notice. Or if you have correspondence with a third party that says that you're going to start an eviction proceeding that predates the date that you became aware of the report to the housing authority or to the Board of Health. So in closing, this case is a reminder that Massachusetts heavily favors tenants when it comes to retaliation claims. If you're considering evicting a tenant after they've made a claim with the Board of Health or taken judicial action, you should really get advice from an attorney before you act, because that move can cost you a lot of money, a lot of time. You look at this case, it happened in 2022, and this decision from the appeals court came out in 2025. If the proceedings are stayed pending the appeal and the trial, we're talking about potentially 2+, maybe even 3 years before this case is even resolved. So if you found this video any combination of useful or interesting, I'd love it if you could subscribe and like the video. It really helps my channel. And if you have any questions, I'd encourage you to reach out. I'll talk to you soon.